Hello and welcome to Newsmax TV. I'm John Bachman. Talking to us right now on the phone from Washington, D.C. is Andrew Walker. He's a policy analyst with the Heritage Foundation. Of course, Andrew, we're talking about the first day of oral arguments before the Supreme Court on the issue of Proposition 8, that California law which defines marriage as a union between a man and a woman. And so we heard the beginning of the oral arguments here today, and of course we're thinking about the Supreme Court case with Obamacare. Oral arguments didn't really play a factor, but do you think that these oral arguments are going to play a factor in this case?
I would like to hope. I would. I think what's important here is that the case be made for marriage. And what's happening so frequently in this debate is people are kind of disingenuously taking the word marriage and applying it to anybody and anyone without properly defining what marriage really is. And what we've seen across America in 41 states is that Americans have overwhelmingly voted to approve and define marriage as the exclusive union as a man and a woman. And it would be premature and it would be wrong for the Supreme Court to step in and end this debate.
And when we talk about the word marriage, to you, is that different than a civil union? Is there a difference?
It is, yeah. I'll give you my basic definition. It's somewhat extended, but it's comprehensive, and I think marriage has about three prongs to it. There's a anthropological reality that says that men and women are inherently different, and there's a biological fact that says reproduction depends upon a man and a woman, and then third, there's a social reality of marriage that says children need a mother and a father. So if you put these all together, you get this, I think, comprehensive definition that says marriage is a natural institution that sees a man and a woman come together as husband and wife to be a mother and father to any children that their union produces. And I think that's qualitatively different than any other relationship kind of known to man, to be honest with you.
One of the questions that came from the bench today, that came from Justice Sotomayor, was, is there in fact an injury to the state by allowing a gay marriage? We heard one of the lawyers, Cooper, argue that there is in fact injury to the state. And how do you define that?
Yeah, it's tough because you often hear the question of how does same-sex marriage harm my marriage? And I think we have to kind of think on a larger scale here, in that this really isn't just about my marriage or your marriage. It's about the public definition of marriage in the public mind. And traditionally, the government has recognized marriage as a unique institution oriented around the procreation of children. And if same-sex marriage becomes the law of the land, we're going to see marriage becoming less of a child-centered institution and more of an adult-centered institution that focuses more on, to be quite honest, the emotional intensities of consenting adults. And I just don't really think the government has a place in regulating relationships based on emotional intensities. I mean, I don't go to a licensing bureau to have my best friend and I's friendship recognized before the state. I mean, the state has historically and legally seen that marriage is unique because it produces the next generation of citizens. And when the Defense of Marriage Act was passed in 1996, there's this absolutely stunning passage in the law itself that says that were it not for the possibility of begetting children inherent in heterosexual unions, society would have no particular interest in encouraging citizens to come together in a committed relationship.
And this was brought up today, and the question was, then what about couples that marry and one of them is sterile or infertile?
Yeah, sure. I mean, we have to remember that all public policy is based on the norm and not the exception. So, I mean, but still, even with those clauses kind of attached to the debate, I mean, we have to recognize that a childless couple or an infertile couple, they still possess the natural essence of marriage, which is it's based on sexual complementarity. There's the sexual act is occurring, but it's not occurring to fruition, and that it's based on a permanent, exclusive relationship. And so again, we're arguing about public policy being based on the norm of things and not the exception.
And in other cases across the country, we've also heard testimony from adopted children of same-sex couples. Mm-hmm. How does that factor into all this? Because you can there's obviously examples out there of couples that have been together for a long time and have raised
Sure.
children, and those are same-sex couples, and people have held those up as examples of how this can work and produce children that are contributors to society and are well-adjusted. So what's the argument against that?
Yeah, I mean, we want to acknowledge and affirm that all individuals can love children. But I also want to step back and say that all the love in the world can't turn a mother into a father or a father into a mother. And we would be again redefining marriage. We would be making it genderless and denying the ideal that children need a mother and a father. And so again, I want to say we recognize that there are, individuals in this circumstance, but we also have to recognize from a larger, broader policy principle that children do best in a household with a mom and a dad.
It's fair to say that even if the Supreme Court does not rule definitively on this case, there's still going to be an impact here. Let's say if the Supreme Court decides to kick this back to the appeals court, what do you think the result will be in terms of the future of gay marriage in this country?
Well, yeah, I mean, right now we're hearing the court cases, and we'll hear the ruling come June. And so there's kind of two different schools of thought that they could issue, either a very broad ruling from both cases that would strike down existing state amendments and state statutes that define marriage, or they could have a very narrow ruling that would be tied to just California alone and to the particular circumstances of Miss Windsor in the Windsor versus DOMA case. So I think what we're going to see regardless is, we're hoping that there will be, that obviously marriage would be upheld, but in the occasion that, same-sex marriage does come down from the court, we're hoping that it's on a state basis, because where we're most concerned right now is seeing this debate continue, and we don't want to see the court step in and kind of end the debate and do the same type of thing they did with Roe v. Wade and create this 40-year culture war that has kind of plagued American politics. And the polls show we're having a great, robust debate, and we don't want the court to end that. And I think more importantly, millions of Americans have spoken out on this issue, and we don't want their voices being overridden by the court.
Yeah, it's a good point, and something that we've heard from both sides of this argument here is why should, say, people in Oregon decide what people in Florida should be doing in terms of marriage and vice versa. So that's why we have the Supreme Court, obviously much smarter, no offense, than guys like you or I, so we'll leave it up to them. So, Andrew Walker, thanks so much for your time, policy analyst with the Heritage Foundation. Pleasure talking with you.
All right, thank you.